Thanks so much. This really does feel like being in the classroom in terms of trying to get everybody to sort of front and center and focus on the topic. The next topic is really one that I think all of us are involved in very closely, and we're paying very intense attention to this these days, and that is how we navigate in the landscape post U.S. Supreme Court affirmative action ruling. Most specifically, it's affected our scholarship programs. We talked about it at length yesterday in the ED session, but we wanted to share a resource with you, and that is our legal counsel, Victoria Muirhead from Stoel Rives, and we at the Seattle Colleges Foundation are working closely with Victoria to navigate some of our work, which this is not something that we've taken on lightly or in the short term. We have been at this for 3 years. So this involves Title VI, Title IX, and I'm sure many of you are familiar with this work, but you're going to learn more today. Victoria is a graduate of the Lewis and Clark College in Portland, where she was editor-in-chief of the Law Review, and she is now, as I mentioned, with Stoel Rives. She specializes in nonprofit law, including charitable giving and regulatory compliance. Sorry about that. And she happens to have been a fundraiser herself. So this is a real bonus for us to have legal counsel who also understands our work. She was in advancement, and Victoria was at Stanford? At Stanford. So yeah, we might have more conversation with her about that as well. But she's here today to talk to us about this critical topic, and I hope you'll join me in giving her a warm welcome.
Well, I'm very excited to be with you all. All right, yes, it's working now. I'm excited to be with you all today. As Carrie mentioned, I worked in advancement before becoming an attorney, and so when I get to come to conferences that are for advancement professionals, I feel most like at home because that's how I came up in my professional career working as a fundraiser. In addition to working at Stanford University, which had, resources, processes, someone that I could go to for every legal question that I had, I also worked at a very small nonprofit organization immediately before going to law school, where I was the 5th employee, and I was the first person who was hired to not do program work. And so I was the person who was in charge not only of fundraising, but also of communications and finance and administration, and sometimes program stuff as well, because I spoke Spanish and we advocated for immigrants' rights. So I'm both familiar with being at that big shop and also being at the smaller shop, where if something needs to be done, then you're the one who steps up and does it, no matter what your title is. So I like to draw on those experiences when I advise clients now that I'm an attorney. All right. The slides are not up. All right, having a technical issue. Well, I will just proceed, and then if you could just signal to me once the slides come back, that would be great. All right, so to start, I was about to show you a disclaimer slide, but I guess I will have to read it instead. And, oh, there it is, great. So the disclaimer is that this is not legal advice. As an attorney, we love to say that before we do a presentation, to just remind people that we're going to be speaking generally about legal topics, but not about how they might apply to your particular situation. I also have another disclaimer that's not on the slide, which is that this particular area of affirmative action and its application to scholarships, to other areas of higher education, is an area where we are likely to see continual change. So some of the things that I'm going to share with you today are taken from guidance that was issued by the Department of Education under the Biden administration. I'm sharing it today because I think it is still legally sound, But of course, it's an open question as to whether or not that guidance will be respected by the new Department of Education Administration, or whether there will be new court cases that come up through the system that eventually change some of the application. I was just talking to a colleague about this a couple of days ago, and we were reflecting on the law hasn't changed overnight from, November to now. But suddenly there's uncertainty about how the law will be applied and interpreted. And so that is one important thing to keep in mind. Here is a roadmap for what I will be going through today. First, I'm going to talk about the Students for Fair Admissions versus Harvard and UNC case, because this is the case that really brought the issue of affirmative action into the national spotlight. And next, I will be talking a little bit about the guidance issued by the U.S. Department of Education around enforcement of scholarships that are restricted on race and sex, and just generally restrictions for any program or benefit that is based on race or sex. And then finally, I will talk a little bit about compliance strategies. So some takeaways for you to think about as you accept future gifts from donors, and also as you look at current gifts that you have on your books that might need to be modified. I will try to save some time for Q&A at the end as well. All right, so Students for Fair Admission versus Harvard and UNC. I think that we're all vaguely familiar, at least, with what happened in this case. This case was brought by a group that had actually spent many years working towards the goal of bringing litigation against universities that have selective admissions programs. The lawsuits that eventually resulted in the Supreme Court decision in 2023 were actually brought in 2014. So they it took many years for them to work their way through the system and finally be heard by the Supreme Court. In this slide, I've tried to boil down the Supreme Court decision as much as possible. It's very lengthy. If you print it, it's almost like a third of, or 3/4 of an inch thick. But here I've just tried to boil it down a little bit. The court held that race may not be used as a plus factor in higher education admissions. The way that the court looked at admissions was that they are a zero-sum game. So by giving one applicant a plus based on their race, you are necessarily giving another applicant a minus, also based on their race. I think many people would not see it or explain it or boil it down in that way, but that is how the court ultimately looked at selective college admissions. The court did acknowledge that there might be times that race could be mentioned. Not that race could be considered in and of itself, but that it would still be appropriate to discuss race. Students can still discuss race in their applications, and I'll read directly from the case. The court said that universities may still consider an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. So you can't consider race for race's sake, but if a student writes about how their racial background contributed to their interest in a certain field of study, the university could consider how that might reflect on the student's intellectual curiosity and how that might show that the student is a good candidate for admission. However, the court cautioned that universities should not use essay questions as a way to get around this ability to discuss race. So you shouldn't, universities can't say, we're not collecting your race, but then have a question that says, please tell us about how your race has affected you, because that would be getting around what the court is holding in this case. In coming to this decision, the Supreme Court said that, this is nothing new. This is what the law has always said, and we're just clarifying what previous Supreme Courts have held. But I think that many legal scholars would disagree with that take, and would say that this actually is a pretty big change from what past Supreme Court cases on higher education admissions have said. In the past, there was an acknowledgement by the court that using race not as the sole factor, but as one factor would be beneficial and permissible. And there was also an acknowledgement of a worthy goal of remedying past discrimination. And as we know, many institutions of higher education, especially those that are most selective, do have histories of discrimination. So they acknowledged that that was a worthy goal. And there was also an acknowledgement that having a diverse student body can have benefits to the entire student body. And unfortunately, the court basically said those are not good enough reasons to discriminate on the basis of race. So that, I think, has rippled out, and many people have started to ask, how might this affect other areas? If the court has said it's not okay to use race as a consideration for selective admissions, what other areas might we not be able to use race in? And that's where scholarships come into play and are implicated. Because while many universities are not highly selective, very few universities, maybe no university has a admissions percentage as low as Harvard's in the United States, almost all universities have scholarship opportunities that are competitive, where not every single student is going to get a full ride, not every single student is going to get a scholarship. And so scholarships are, I think, can be analogous to that competitive admissions letter. Getting that scholarship can be very competitive as well. So I will talk more about that, but before I proceed into that, I want to talk a little bit about some guidance that was issued by the Department of Education shortly after the Supreme Court decision came out. So the Department of Education, recognizing that the Supreme Court decision was taking away a very important tool that universities had been using to build diverse student bodies, issued a question and answer document that laid out some strategies for how universities could comply with the Students for Fair Admissions case, and also for what they could do to still champion having diversity at their schools. And there are many different strategies that are laid out in the question and answer, and that's something that you can still find online. But I'm just highlighting here a few of the strategies and a few of the points that they made that stood out. So I think most importantly is that schools may still state a goal of enrolling a diverse student body. So just because you can't, directly consider a student's race in giving someone a scholarship or conferring a benefit doesn't mean that you can't still state that it is important for your institution to enroll a diverse student body. Additionally, the DOE pointed out that schools can still consider other factors that would contribute to a diverse student body that are race neutral. And race neutral means exactly what it sounds like. They are factors that don't have to do with someone's race. For example, someone's family background, whether or not they are the first in their family to attend college, information about where a student attended high school and what the high school's demographics are, or test scores, what that looks like. And of course, you can still look at a student's lived experiences. As the court mentioned, if a student writes about how their racial background contributed to who they are, showed how they overcame a hardship, or why they developed an interest, those factors can still be considered. The one caution here is that it is important to not use these race-neutral criteria as a way to get around what the court has said. So, here I've noted that factors cannot be a proxy for race. They have to be things that you're really striving for in and of themselves. And I do think that many people would agree that striving for more access to education for students who come from a family where they're first generation is a worthy cause, or making education more available to students who went to high schools where not many students go to college is a worthy cause. And so I think for many schools, it's not going to be difficult to really champion and center these things. And then finally, schools may still foster a sense of belonging through culturally specific opportunities and programming. But the key here is that those opportunities must be open to all students. And that's actually another very fascinating area that there's a lot of information on, is when opportunities are not open to all students. So as long as they're open to all, generally they're going to be fine. All right, so talking a little bit about scholarships. As as I noted, the Supreme Court case was really just limited to higher education admissions. And as you know, when the Supreme Court speaks about something, that kind of settles the debate. So if there's lack of clarity around what is okay and what is not okay, once the Supreme Court decides, that kind of ends things. So as far as the Supreme Court has decided today, it is not permissible to use race as a plus factor in admissions. The Supreme Court has not also decided that it's impermissible to use race as a plus factor in scholarships. However, I think that if someone were to try to take that case forward, hoping to get a different result, it would probably be very difficult, because you can see those connections between the selectivity of admissions at a school like Harvard and a scholarship that is limited to maybe one student receiving it out of a student body of thousands. So I think that someone would be probably unlikely to succeed today if they decided that they wanted to dig their heels in and really challenge and say that it was okay to have their race-based scholarships. I also think it would be challenging because the Supreme Court has kind of ignored or decided that they're not going to give a lot of importance to past discrimination, to the goal of having a diverse student body. And so things that before universities could rely on to defend their selective admissions programs are no longer given as much importance by the court. Also, it might be kind of interesting to know that in 1994, there was actually a case decided in a different circuit, so not in our area of the country, but in the Fourth Circuit, that already said that already prohibited limiting a scholarship opportunity to students at a state school on the basis of race. So there's already been like this one court case out there from 1994 where that was initially decided. And then the other thing that might be surprising for some people to learn, probably no one in this room, but probably your donors who you talk to, is that the Department of Education and the Office of Civil Rights, which is part of the Department of Education, has for a very long time already been interpreting Title VI and Title IX as prohibiting awarding scholarships on the basis of race or sex. So this means that the Office of Civil Rights has already been investigating complaints when they receive complaints about scholarships that are limited on those bases. So while it's probably very unlikely that a race or sex-based scholarship at your foundation will become the subject of a court case, it is a lot more likely that it would become the subject of a complaint by the Office of Civil Rights. So we're going to talk a little bit about the Office of Civil Rights and what they're looking for, how they enforce the laws when it comes to scholarships. So the Office of Civil Rights has a mission to ensure equal access to education and to promote educational excellence through vigorous enforcement of civil rights in our schools. That was their mission in October. It's still their mission today. The OCR receives complaints about discrimination, and once it does, it has a duty to evaluate those complaints. And the important thing to keep in mind here is that complaints can be made by anyone. So it's not just, a complaint that comes from a student who says, I applied for a scholarship and I didn't receive it because I was not a certain race or a certain sex. But the complaints can be made by someone who's on the other side of the country, other side of the world, who is browsing your website and sees that you have a scholarship that says this scholarship is for Black students only, or this scholarship has a preference for women students. So the complaints can come from anywhere. And in my experience from having helped with a few of these OCR complaints, they very rarely come from students. And I don't think that they very often come from faculty or staff either, but they just come from people who believe that it is their duty to help enforce these laws. And once OCR receives this complaint, if on its face it looks like there's a potential for violation, they will investigate. And that process can be time-consuming, it can be costly, it can require you to get an attorney. I should clarify that these complaints won't be made to the foundations themselves. but they are made to the colleges. And the reason that the colleges are subject to OCR oversight is because they receive federal funding. And that is how they get you by the purse strings. And that is also why not only public colleges are implicated, but also private colleges. So OCR complaints can happen whether you are at a state school or whether you are at a private school, because all of these higher education institutions receive federal funding. However, where you will be implicated is because foundations are often the holders of these scholarships that have been established by donors. And so you're often the ones who are, publicizing the scholarships, working with the institutions that you serve to award the scholarships in some cases. Or sometimes, the institution that you serve is just, simply posting a link to your website that documents all of your scholarships, and that's not okay, according to OCR. So that is a little bit about how OCR enforces. These are the laws that OCR specifically enforces. Title VI, which has to do with race, Title IX, which has to do with sex, Section 504, which has to do with disability discrimination, and also Age Discrimination Act. I'm not going to talk about the second two today, but I did want to just highlight in this slide that this is the laws that are enforced by OCR. OCR does not cover employment discrimination, nor do they cover religious discrimination. So that is different parts of the government that are focused on that. So I know that we've talked about discrimination a lot. What does discrimination mean? Boiled down, it means unfair treatment based on a protected characteristic. And as we discussed with the Supreme Court case analysis, discrimination doesn't just mean stopping someone from participating or receiving a benefit, but it also means creating a benefit that is only available to members of a certain group based on a protected characteristic. I also want to acknowledge that the concept of discrimination has changed over time. As I mentioned earlier, the Supreme Court's most recent decision was a departure from prior court decisions where there was that acknowledgement that a past history of discrimination might necessitate schools making some different decisions moving forward. And the frustrating thing here is that means that some of the opportunities that were created with a goal of rectifying past discrimination are now considered discriminatory. And that is why, many of you, as I learned a little bit yesterday, have scholarships at your foundations that are restricted on sex or restricted on race. Because there was a time when it was seen, when these scholarships and opportunities were seen as good ways to help with past discrimination. And before proceeding, I just want to note that I think it's important to understand how the law is interpreted and enforced today for two reasons. One reason is that as staff at a foundation that supports a college, you have an obligation to avoid placing both the foundation that you work for and the college that you support at legal risk. And just as you would exercise additional due diligence if a donor came to you tomorrow and said, I would like to give you a gift of property that has tenants, that has environmental hazards, you would be doing your due diligence. You wouldn't just say, yeah, we need the money, we'll take it, because you know that some gifts are not worth accepting. And this is a similar situation where you need to be exercising due diligence if a donor comes to you wanting to place restrictions on a gift that you think might put your organization or the college that you support at legal risk. And the other reason why it's so important to understand how the law is being interpreted and enforced today is because once you understand that, then you can start to strategize about what you can do with the tools that you have available. So diving into Title VI, which, as I've mentioned, prohibits discrimination on the basis of race, color, and national origin. The OCR has also clarified that this includes shared ancestry or ethnic characteristics and citizenship or residency in a country with a dominant religion or distinct religious identity, So that is, kind of the full scope of how OCR is currently interpreting discrimination under Title VI. It's important that opportunities not be restricted to students based on any of these characteristics. And Title VI has been interpreted in many different, not only to prohibit scholarships that are restricted based on race, but also to prohibit awards programs, to prohibit clubs, to prohibit other opportunities that are restricted on these characteristics. So that's important to keep in mind, that probably the colleges that you work with have also had to make adjustments in other areas that foundations never even touch upon. There are, on OCR's website, they actually publish many resolutions and many complaints that they investigate, and those can be a very helpful source for understanding how other institutions, where other institutions got in trouble, and also what they did to remedy some of the programs that might have been discriminatory. And then Title IX prohibits discrimination on the basis of sex. The Supreme Court has previously said in another decision that had to do with employment discrimination that sex also includes sexual orientation and gender identity. However, OCR recently released some updated guidance where they're saying that they're not going to interpret sex to mean sexual orientation and gender identity. So, I think it would probably still be safe to not discriminate on those bases, but the OCR is kind of trying to figure out where exactly they're going to draw the line right now. In the context of scholarships, I would just put a small asterisk here that there are some very limited situations in which scholarships may be granted on the basis of sex. I'm not going to dive into that today. It has to do with the concept called pool and match, and it is going to be a fact-specific inquiry as to whether or not your institution can actually use that method in order to grant some sex-restricted scholarships. But I do want to just place that asterisk there in case you fall into that category. That might be a thing to dig deeper into in the future. And next I want to discuss how these rules are applied by OCR. So schools that offer these restricted scholarships are at risk of enforcement actions. And as we discussed, this can mean OCR reaching out and asking for changes to be made to content on a website, for OCR to ask for information about past scholarships and how they were awarded, and it could also even lead to OCR doing continual monitoring to make sure that if you attest that you've made changes, that you're actually really abiding by those changes. So that's obviously a legal risk because it can be time consuming, it can be expensive to deal with, even when resolutions are quick. A couple of other things that I think are super important to highlight here is that for OCR, there is no difference between a requirement and a preference, because this is a question that we frequently get. If a scholarship says, I would prefer for a woman student to receive this scholarship, surely that has to be better than a requirement. To OCR, it isn't, because it's still giving someone a benefit based on their sex. So that does not save a scholarship to include that language. So do not accept scholarships from donors with that language. And I would also say don't accept them either, because you don't want to give donors a false idea of how the scholarship will be administered. And we'll talk more about that later. And then another thing that's super important here is that for OCR, they can open a complaint and they can look into a complaint just based on having a link to another website on a college's website that advertises scholarships that are restricted on the basis of race or sex. And so the good news is it's very easy to delete a link from the website. So usually that's a very short investigation. But I think that where that can be very important is because your foundations, you have the funds that support the college students. The colleges may not be administering the scholarships directly, but they can still be the subject of an OCR complaint if they are posting links to the foundation website that then says, please apply for these scholarships that are restricted on these different characteristics. so I have seen that happen before, where someone posted actually a link to a website that just offered a lot of different scholarships for students studying a particular area. They weren't all restricted on the basis of sex, but the mere fact that they posted this led to an OCR complaint, and they had to confirm that it was taken down. So at least that was a very quick and easy resolution, but it does show that, you know, there are some people who are spending the effort to really dig into those links and make those complaints if they see something. And that is, I think, very important, because as foundations, most of you are likely organized as separate 501c3 organizations, but just because the scholarship is separate and isolated doesn't mean that there isn't that risk to the college that you serve. And I would also just note here that as foundations, you are obligated legally to support the colleges that you are affiliated with. And I know that for most of our foundation clients, this means that they would not want to do anything that would put the college that they support at risk. So to that extent, I would say that even if, you know, maybe the foundation is not going to get hit with that OCR complaint, the foundation's not going to have to get a lawyer for it, the foundation should still not be offering scholarships on their website, or not on their website, that the college wouldn't be able to award itself, or that the college cannot publicize without opening themselves to risk. And this also just makes sense too, because if we're not able to publicize those scholarships, we're not able to reach the students who need them. So now we're going to spend a little bit of time talking about compliance. And I think the most important thing when it comes to being legally compliant in any area is equipping yourself with knowledge. And the great news is that simply by being here today, you've already learned a little bit more, I hope, about this area and about how the law is applied. And now that you have that knowledge, you are better equipped to look at the scholarships that you currently have, and also to talk to donors and explain why an organization can no longer accept certain restricted scholarships or may need to make changes to existing scholarships. And then, further to compliance, I would suggest that moving forward, organizations should not establish scholarships that have race or sex-based restrictions. And remember, a preference is also considered to be on par with a restriction. And this is important not only for legal risk, but also because you do owe it to donors to accept charitable gifts that can be put to use. You should not be accepting a gift that is going to just sit on the shelf and not actually be applied to help students and to help the colleges that you support. You should be accepting money that can be put to use. And just as you wouldn't accept a gift where a donor wanted a restriction that would take more staff time than it was worth, you shouldn't accept a gift where you can't reasonably expend it. You might also consider if there are race-neutral criteria that you can offer to donors instead, who are very set on having restricted criteria. But I would offer a couple of cautions here. One is, as I mentioned earlier, you can't use these race-neutral criteria as a proxy for race. And you should absolutely not promise a donor that while you're going to make the criteria first-generation college student, you will make sure that a student of color receives a scholarship. No, the scholarship must truly be race-neutral, not only in how the gift agreement is written, but also in how it is applied. So that's one caution there. I know that, sometimes donors try to, push the limits of what an institution will allow. And so just, be cautious there, and also encourage your gift officers to be cautious there. And then I would also, as another caution, just say that less is more. And what I mean by that is that fewer restrictions on donations are just so much better for an institution. So to the extent that you tell a donor, I'm so sorry, but here's some reasons why we can't accept this scholarship that's restricted on the basis of race, you don't have to then say, but how about we look at this other criteria that you can use instead? You can just say, but we would love to accept this scholarship and award it to a worthy student. And I just always emphasize that because it's something that I learned as a fundraiser, and it's something that I'm sure you're all very aware of as fundraisers who see how money is spent. And it's also something that I've gained an even greater appreciation for as an attorney, because I'm often asked to help clean up scholarships, or actually often not even scholarships, but to clean up funds that just have so many restrictions on them that it is pretty much impossible to spend them, or where it would just be a waste of staff time to spend them. All right, and so then finally you might be thinking, okay, that's great, but what about existing scholarships that we already have? Do we need to just stop awarding them and ignore them? What can we do when it comes to those scholarships? So in the next few minutes, I'm going to discuss some paths for modifying scholarships where there are criteria that are not possible to award. And I would just note that what I'm going to discuss in this next part of the conversation doesn't just apply to scholarships restricted on the basis of race or sex, but it can also apply to any fund that you might have in your collection of funds that potentially is troublesome to award. So if you have some dollars that are sitting unspent, maybe it would be perfectly legal for you to spend them, but you just really don't want to because it would be a pain to administer, then these next paths could be perhaps provide a solution for those funds as well. So now we're going to dive into state law, specifically into the Uniform Prudent Management of Institutional Funds Act, which is also referred to as MIFA. This is an act that many states have adopted, and it provides a path forward for modifying restrictions on funds when those restrictions have become unlawful, impracticable, impossible to achieve, or wasteful. And I've included there the citation for the Washington Act and also the Oregon Act. I'll also note that MIFA actually covers a lot of other things that are very important to your institution. For example, it talks about how much would be appropriate to spend on an endowed fund every year, and how you need to manage those endowed funds and other funds in a prudent way to make sure that they continue to grow. You shouldn't do risky things with the donor funds that you receive. But one of the things that I often turn to at MIFA for is for modifications of funds when it is unlawful, impracticable, impossible to achieve, or wasteful to administer them. So under MIFA, there are these 4 routes that you can take in order to modify funds. And I've organized them roughly in order of what's easiest to what is more difficult. And obviously the most difficult is court petition, just because it is a timely process and you probably will need an attorney for that. But these other options might be options that you can pursue on your own. So the first option may or may not be possible, but it is a suggestion, or I guess I would make the recommendation that if you have a gift agreement with a donor, especially if it's for an endowed gift that's going to exist in perpetuity, that you should include a clause along these lines in your gift agreement. And this, I've called it an out clause here. Sometimes it's called a savings clause, unforeseen circumstances clause. You can call it whatever you think is appropriate. And here's some sample language that I've used before that permits the board of an organization to modify or release a restriction on the fund if it becomes unlawful, impracticable, etc., to realize that restriction. And if you have a clause like this in your gift agreement, then that gives you a really nice path forward for putting a fund to use if it's not possible to use it in that way anymore. I would say that it's very important to remember, especially for gift officers. I know that we get judged on metrics, and so I know that sometimes it's very tempting to just accept all the gifts that you can. But remember that when you accept an endowed gift, you're accepting a gift that will outlast your tenure at your institution and that will outlast the donor. And frequently as an attorney, I'm called in to clean up funds that were established decades ago. And it's usually not because the fund had an unlawful restriction, but it's usually because they're restricted for programs that don't exist, have really bizarre requirements that would be so onerous to follow through. And that just takes institutional dollars. And as much as I enjoy my job and I'm happy to help and love to earn an income from that, I wish as a personal, as a former fundraiser, that I didn't have to come in and that there was an easier way for these funds to be modified. And so if this is not already a non-negotiable for donors who are establishing endowed funds at your institution, then it absolutely should be. If a donor is like, I'm really worried that you're going to just start using this in a different way tomorrow, then you can get creative. You can say if it can't be used for program X, then it will be used for program Y, and if it can't be used for program Y, it will be used, like you can get creative with it as long as the end result is that you do have a mechanism to release the restriction. I do remember once when I was working at Stanford Medicine that we had a donor who was like so paranoid about this that there were like 4 different things that a fund could go through before it could be released by the board. But you know, at the end of the day, like that did provide that protection for the organization. And related to this, the next path forward is donor consent. And UP-MIFA says that basically anything in a restricted fund can be changed with donor consent, except that a donor can't consent to something that is not charitable. And that just totally makes sense because you can't accept a gift that's not charitable to begin with. The important thing to keep in mind here is that the consent must be from the donor. So a common question that we get is, donor has passed away, but we're still in contact with their child. Can the child agree to the modification? And unfortunately, the answer is no. Unless the gift agreement said that the child could make changes on the donor's behalf, the law says that really no one other than the donor can agree to that change. So the other thing I would say here too is, you know, what if you have a situation where you have a gift, a scholarship that is restricted on the basis of sex, and you have that out clause in it. You have that great language already. Can you just go ahead and just change the modification without receiving the donor consent? The answer is technically yes, because you've already pre-received their consent through this clause. But I think, as almost everyone in the room would say, that would be a terrible thing to do, because you don't want a situation where a donor is surprised when they've learned that you have released a restriction without notifying them first. So even though it will take more time to get their consent and to make a change to the gift agreement, it is worth it because it is important to steward those donors and not have them be shocked when they think that their scholarship for women was restricted for women, and then they get a thank you letter from a student that doesn't appear to be a woman. So then this is the third path forward for modifying funds that you can't spend, and that is providing notice to the Attorney General. And what is really nice about this path is that basically if you can prove, like if you can satisfy all of these requirements, then all you have to do is just give notice to the AG, and then after a 60-day period, you can release the restriction. I suppose that there's always the possibility that the AG would say, please wait. But for the most part, if you have a good argument in mind for why a restriction is unlawful, impracticable, etc., then this should be a path forward for you. The challenge about this path is that the fund must be less than that amount, which increases every year, which actually I really like because Oregon's does not increase every year, and so we're stuck at a very low amount for Attorney General petitions, but Washington has a better statute because it increases. So the fund has to be less than that amount, and it also has to be older than 20 years. So this is a really good path forward for old funds that you have where the donor is deceased and it would be difficult to otherwise change the restriction. And then finally, this is the most onerous path forward, where you prepare a petition to the court and also provide notice to the Attorney General in order to release a modification on a fund. That said, this path can still absolutely be worth it if you have a large fund that is sitting unspent. I know that I've worked on this before for funds that were, 6-7 figures, where that's money that could actually be having a very meaningful impact. And the only way to make that happen is to petition the court. And also probably where you need an attorney. So those are just a few strategies for moving forward, for fixing up funds that can no longer be spent or where there's a legal risk to spending them. And remember, this can be used for other types of funds as well that your institution holds. So with that, I will just leave you with the closing thought. that once again, as I said earlier, this is a rapidly changing area. So it is important to revisit compliance strategies regularly. It is completely possible that everything we've talked about today will be different if we reconvene in 3 years. I hope that that won't be the case, but it might be. And so it's important to assess the funds that you have and to keep an ear to the ground in terms of how the law is being interpreted. Talk to your colleagues. I think the plenary discussion yesterday was so great because people were sharing stories of what they had experienced and what they had seen. And oftentimes as an attorney, the way that I'm learning about what's going on is because I'm working with clients who are sharing what happened with their OCR complaint. And that's like the best way that I'm learning, not necessarily through reading a legal treatise on this subject. So staying in contact with your colleagues, coming to conferences like this, I think is just such an important, critical step for compliance and for understanding how the law is being interpreted. And so with that, I will now take some questions. Thank you.
Hello. So donor consent, does that mean a conversation that you document later? Does that mean a signed piece of paper? Does that mean an entirely redone gift agreement that the donor signs? Does that mean an email?
Yeah, that's a great question. So that means something that is written, and I would say that written can include an email. So if you email a donor and you say, you have this scholarship, it's restricted on the basis of sex, can we release that? And they write back from their actual email and say yes, then that would be a record. That would then become part of the gift agreement. So you would, want to keep those things together. Another very common way that I see it done is someone executes an amendment. So you just say, this was a scholarship restricted on race. We are amending this to delete section 2.1. But yeah, I would just say it should be written is the important thing. It shouldn't just be something that they've orally agreed to.
I'm Danielle from Green River. Hi.
Hello.
I have, so just a clarification for you. So you were saying that if we have stuff on our website that would be like an outside scholarship, so like for example, the Star Optimist Live Your Dream Award is for women only, like we shouldn't post that on our website.
Yeah, that's it. That is what I am saying.
Okay.
So colleges,
just wanted to clarify.
Yeah, yes. And that is something that OCR does look into, is when you're posting a scholarship, even if it's not one that the foundation is administering or the college is administering, if it is just promoting an opportunity that is restricted, then it can be the subject of an OCR complaint. And there are, again, there's some resolutions and there's some examples out there where colleges did come up against this issue.
And thank you for all this, Josh Crispin Highland College. Following up on that, what if somebody on campus emails information about whether it's the Star Optimist or a scholarship for Asian American Pacific Islander students or something like that? It's not on the website, but it's sent by a staff member out to campus by email. Is that, do you have any thoughts?
Yeah, well, I would say that when we think about what's going to put you at greatest legal risk, it's obviously going to be the things on your website, because that's the things that anyone can see. It's going to be, I think that when you're asking, is it legal to send out a list to all the students where you advertise scholarships that are restricted on sex or race or the answer would be no, that it would still not be permitted to do that. I think the risk would be lower because it's less likely that the email is going to make its way out to the public and to people who would be trying to bring enforcement actions. But I think it is aware that people should be aware that that's still not permitted.
Yeah, and a quick follow-up on that. It hasn't happened to us yet, but if somebody does a public records request on anything related to scholarship promotion, that emails like that could come up in a public records request.
Yeah, I'm not as familiar with the Washington public records law, but it seems like that's a possibility. Also, the thing about OCR as well is that if you do get on their radar, there is always the possibility that they will ask for more follow-up information. So they could request that as well if for some reason they were alerted to that. Yeah.
Hi, thank you very much. Michael Cabrera, I'm with Bates Technical College down in Tacoma. This is more of a speculatory question, so it's okay if you can't answer it. But given that we've talked about Title VI and Title IX, race and sex discrimination, in the wake of changes with our administration, the way DEI and affirmative action is being handled, other protected characteristics such as veteran status, do you think that could eventually come into question? Bates, in particular, we have some scholarships that are veteran focused, so that's kind of where my speculation is starting to go.
Yeah. Well, I would say that I don't know if I would think that the current administration is that focused on other areas apart from sex and race, and I think especially race. So I don't know that it would trickle out into other areas. Also, the Supreme Court historically has interpreted any restriction that's based on race they've held it to a higher standard than other restrictions. And they've also held restrictions based on sex to quite a high standard as well. And so there's more burden on someone who is discriminating on those bases to prove that they have a compelling reason to be discriminating. And other areas like disability discrimination or age discrimination, there's a lower burden because there's more of a realization that there might be compelling reasons to have to discriminate or to not make an opportunity available. And I think that an easy example for this is when we think about age discrimination, that is prohibited, but there are many opportunities when you can make something available to someone based on their age. So for example, if you have a scholarship that's restricted to upper class students, that would be permitted, and you wouldn't have to, you wouldn't have to prove that there's a compelling reason to do that. It would be fine to do. Yes. Yeah, well, I think it was actually Annabelle who was, yes. The question was yesterday we talked a little bit about acquired characteristics, and I think it was Annabelle who pointed out a good metaphor that when something is acquired versus something that you're born with, there's a distinction there. So you can't really change your race, for example, but you can change your veteran status if you wanted to, or you could change your status as someone who's majoring in a specific area.
Hi, I'm Tom with Edmonds College. I think I know the answer, but I want to get some advice. So I've been thinking about moving our staff. So we're employees of the state, but our emails, and we have a database. I'm thinking about moving everything off of the college system. However, we're still employees of the college, right? And I understand that if we're sending emails, that can still be a public request, blah, blah, blah. But if we move everything to our foundation, in terms of our emails, our data, how does that work with public requests?
Oh gosh, and this is where I would just have to say I'm not very familiar with the public records request law in Washington. So I would probably encourage you to talk to counsel who has more of that expertise. Sorry.
Can you share in Portland how it works then?
Well, in Portland, Oregon has a very specific public records law, and it's a bit murky, but we've always interpreted it to be that the information held by the foundation is not subject because they are a 501c3 organization and they're not a public body.
Thank you.
Yeah.
Hi. Is there a difference with Native American? There are other laws and legislation that surround that. Is there a difference?
Yeah, that's a good question. If there's a difference for Native American scholarships, I'm not deeply familiar, but I do know that it is permissible to restrict a scholarship or opportunity by tribe enrollment, and that is just something a little bit separate. Yeah.
Hi, Kim with the Olympic College Foundation.
Yeah.
You spoke on this a little bit yesterday about gift agreements that are for scholarships intended for citizens of the United States or speaking to citizens in residency. I was wondering if you could speak to that a little bit today.
Yeah, so as one of the previous slides noted, that the definition of, or what's encompassed by race also includes national origin. And so I think it would be legally risky to have a scholarship that is limited to students who are U.S. citizens. It would probably be fine to have the scholarship be for students who are citizens or permanent residents. And I don't see any issue with limiting a scholarship to residency, because there would be, for one, residency in a certain state is not considered to be a protected class like the ones that we discussed. And also I think there's really compelling reasons why you would limit a scholarship based on residency. All right.
Hi, this is Matt Banderas from Lowell Community College. We currently use a fund description to make our awards from, and that part of that process involves a paragraph or two about the donor and why they give, and it provides a nice stewardship touch point for our donors. If that paragraph were to include some language that indicates that they had a preference or that they were somehow benefited by support from protected status or classes, but the actual bottom half of the document that lists specific awarding restrictions did not include that, is that problematic in any way, or is that a way to kind of
I
still
think
honor the
I would
donor?
just say that you would just want to make it absolutely clear. And like there was a few years ago, the Department of Education issued some guidance on sex-restricted scholarships, where they actually gave various examples. Like they really tried to get into it. Like if you have a scholarship that says like this is the college women's scholarship, that's probably going to get you an OCR complaint. But if you say it's the college women's scholarship, it was created in honor of a group that was founded in 1920 and it's open to all students, then it would be fine. And so the important thing there for legal risk is that if you do want to include something like that, it could be perfectly legal to do so, but you just want to make it absolutely clear that while something is called a women's scholarship, or while someone's talking about how they were passionate because they think it's important to have women in a certain field, that it is very clear that like this scholarship is open to all students.
Excuse me. I'm Ciela. I'm the scholarship coordinator for the Edmonds College Foundation. Related to that, because everybody's got a question about this right now, you mentioned in your slides that previously Title IX did include sex, sexual orientation, and gender identity. Most of us know those are all different, and now it doesn't include that. So
yeah, so this is
particularly the sex versus gender identity thing. Like, what?
Yeah, and this is just like a really. So what happened was that a few years ago, the Department of Education decided to try to update a lot of their Title IX guidance. And as part of updating that guidance, they said that they were going to interpret these other classes to be included. And really the goal there is not scholarships at all. Like that's not what they were concerned about. They were concerned more about protections for students on campus and ensuring that students couldn't be discriminated against because they are transgender or because they are like other characteristics that are not like strictly like what has been traditionally defined as sex. The Department of Education recently, like at the end of January, issued new guidance saying like, forget that. We're saying that sex means man or woman and that's it. And so, and that's kind of in line with what Trump has stated in his executive order, that that's how he's interpreting that, and that that's kind of where that analysis ends. So the now DOE is basically saying we're scrapping our new regulations, we're going back to old regulations, and but that really had more to do about like services on campus for students.
So they're just scrapping gender identity as a whole and just saying we're not thinking about it because we're pretending it doesn't exist?
They are scrapping it because they're saying it doesn't exist. Yeah, and you can find the letter on the DOE website where they post what their new stance is.
So if it doesn't exist and being gay is obviously a choice, does that mean we can award scholarships targeting that demographic?
Yeah, I mean,
malicious compliance?
Yeah. I will not opine on that, but it is interesting when discrimination has, come, like how it's applied is like so convoluted now.
If we have a gift agreement that has that out clause, what is the next step? And how does our board do we take action on that? How do we document it? What does that documentation look like?
That is another excellent question. So imagine that you have a scholarship that you need to modify and you have a clause that says something like what the clause I shared earlier said, that the board can decide to modify. The way that you would go about doing that is presenting that to the board, having a very clear resolution about what exactly they're modifying, and then have the board approve it and save that documentation. And you would keep that documentation with the original gift agreement to show that it had been modified. Yeah.
Michael Beneke with the Seattle Colleges Foundation. You talked about student groups that might have, like, I don't know, Asian students or Muslim students, or what about a program that was like mentoring men of color? You said it had to be open to everyone, but does the group have to, how active does the group have to be in communicating that and taking proactive action around that inclusion?
Yes, so if there are groups on campus, so it's still permitted to have a group on campus, like in law school I was part of the Latinx Law Society. It's still permitted to have those groups. They just have to be open to all. You don't have to make a proactive effort to go out and recruit people to join that group who, don't care to be part of it. But you can't turn someone away, and you can't ask someone to say, like, as part of membership in this group, you have to demonstrate that you are Latino or whatever else.
Hello? Okay. Along the same lines, I'm curious, the Men of Color program, so there is one that exists. There's funding that goes directly towards it. How does that work? Because as you said, the Men of Color program can be open to anyone, but there's some funding that's been raised to go directly towards the program, not the individual. I'm curious your take on that.
Yeah, I just am not familiar enough with the program to be able to say what permits that to go forward. Yeah. Well, I know that it's just about lunchtime. I'll hang around for a few minutes if people have follow-up questions, but thank you so much for your time and attention.
Thank you so much. Can you hear me? Oh, there. Okay. There's a little lag when you turn it on and off. So, interesting conversation, more to come. Obviously, it's a changing landscape. We're going to break for lunch. Please enjoy yourselves. We'll be back at 1 o'clock. And just a quick note, the folks in the back of the room, SCC TV, thank you so much. They're recording the session, because as you can see, there's some really meaty information that we want to share out. So thank you all for participating. We'll see you at 1.